We're live on Zoom and Facebook as well. The participants are pouring in.
So we'll just wait for the maximum number of participants to reach and we'll start.
Of course, of course.
Yes, sir. Yes, I think we reached. Good day to all the attendees and the panelists gathered here. And I'm Shanmugadev. I'll be the host for this webinar session. And we have our lead panelist, Professor Sundra Rajoo. And our webinar topic is fundamentals of award writing and the possible pitfalls and arbitrators view. And we have Mr. V.Inbavijayan, who is our project advisor, under whose guidance these webinars are being conducted. And we have managing committee member, Mr. Swethan, who will be the moderator for this webinar session. So, in a brief about KFCRI, Kovise Foundation Conflict Resolution International is one of its kind of institution and one of the fast growing institution globally. So we function as of now in two major bifolds. One is acting as an AIADR institution and the other is accreditation body. So as an AIADR institution, we have our own institution rules for arbitration, mediation, and for other AIADR practice as well. We do even have our own rules for tribunal secretaries. And to be acting as an accreditation body, we disseminate knowledge for various professionals, and we conduct trainings for various professionals in the field of in the various fields in the field of arbitration, mediation, negotiation, and even we are starting as of tribunal secretary as well. So to do a more favor of all of us, as a bit of housekeeping rules, I would request all the attendees not to use the chat box unless you're facing any technical glitch or any other glitch. You can communicate with us through the chat box. And I would request all the attendees to put all their questions in the Q&A box now and then. Now I would like to give up my turn to Mr. V.Inbavijayan to give some introductory remarks about our lead panelist.
Thank you, Dave. Welcome to all for this webinar on a special occasion on 23rd May 2020, particularly having my old grand friend, Professor Datuk Professor Sundra. He is going to take the topic fundamentals of award writing and possible pitfalls in an arbitrator's bird's eye view. To share about Professor Sundra Rajoo, he is a founding president of Asian Institute of Alternative Dispute Resolution, and he is a very prominent chartered arbitrator as well. To add on, he was a former global president of Chartered Institute of Arbitrators, and interestingly, he is practicing as an advocate, solicitor, architect, as well as town planner. But most of the participants, I think they would recognize Professor by identifying him as author, co-author of several books, particularly on the Malaysian Arbitration Acts, the recent amendments also. Further, Professor is a very prominent leader in construction arbitration arena. I take this opportunity to welcome Professor Sundra Rajoo for sharing his knowledge on the award writing, particularly his expertise, what he has gained or provided with the diploma courses of Chartered Institute of Arbitrators, which he brought into Malaysia and the Far East region. And this information is going to be the valuable information for participants, because many participants are aspirant to become arbitrator. The essential role of an arbitrator is just to write an award. That award has to be enforced. I think now Professor is going to share about how an award is going to be enforceable without any glitches. Thank you. Welcome all.
Thank you, Imba. Sudhir.
Thank you, Mr. V.Inbavijayan, and thank you, Mr. Shanmugadev, and a very big welcome to Professor Sundra Rajoo, and of course all the attendees from around the world. A very good morning, and good afternoon, and good evening. So this is quite an interesting topic, and I'm really glad that I got to moderate this topic, because I've been in touch with Professor Sundra Rajoo, and we've been working for the last 1 week on how to deliver the perfect webinar to you within a span of 45 minutes or 1 hour. So we are trying to cover a huge topic, which is usually for 3 days in a training into 45 minutes. And if you have any questions right now or throughout the course of the webinar, you can put it in the Q&A box. We will try to answer as much as possible here. If not, we have mail later. Thank you. So now a brief introduction on the topic as well. So everyone knows what an arbitral award is, but I would like to ask Professor Sundra Rajoo to start off the entire webinar by defining what an arbitral award is, and then move on to tell what different types of arbitral awards that are in practice. And see, the main part of an award is the intricacies involved. That is, the particular subject matter, each subject matter has its own intricacies as well. But to a common notion, an award has a standardized form, and each arbitrator has its own style, and each forum or each jurisdiction maintain their own styles. So I would like to humbly ask Professor Sundra Rajoo to share what his standard is and what his style of writing an arbitral award. And one interesting thing which I thought from the discussions we had in the last few days is that any seminar or webinar which I go to, people tell what the standard of or format of an award is alone. But Professor Sundra Rajoo is planning to go a step ahead. He is planning to teach you the decision-making process as well. So this is what is failing in lots of seminars about an award writing. So people know what the format of the award is as well, but people don't know how to arrive at a particular decision with proper consensus. So this is majorly the summary of the entire webinar which we have today, and I'm leaving the floor to Professor Sundra Rajoo. Thank you so much for joining us.
Thank you, Sudevan, and all of y'all. Very good morning, afternoon, or evening, wherever you are. And I'm actually delighted to be doing this. As I've been asked to actually follow a quick thing, I'm given 45 minutes to do it. So I decided to prepare some slides, and through the slides, try to reach out and tell you all what we are going to do. I'm going to talk about fundamentals of award writing, and then we're going to talk about some of the pitfalls as we discuss this. And then I think there will be questions and answers. And let me start straight away. If you go and check any book, you will find there is no, legislation. You check legislation, they never define what is actually an award. They will go around and say what an award does, but they never say what an award is. So I think the best way to actually go to what an award is to actually look at a dictionary definition. So it's a decision or a determination rendered by arbitrators or extrajudicial deciders upon a controversy that is submitting to them, and it has to be a document or in writing embodying such a decision. And I think the one thing is that the New York Convention, which is the International Convention for the Enforcement of Awards, what they do say about arbitral awards is that they say that it is not only made by arbitrators, but also made by permanent arbitral bodies. So there's a suggestion that awards can be a document in writing. Then it goes on to who can make the awards. It's an arbitrator, a panel, or an arbitral body. So then we actually go to types of awards, and there are many types of awards, and you will be quite astounded when you start to do the work that particular situations may call for an award, and it will be called that kind of award. But normally we are always used to what is called a final award, an interim award, or a consent award, or agreed award. Then you have such things called a default award. When somebody doesn't turn up, you still have to come out with an award, but it may be a final award, but in actual fact it's a default award. Sometimes there's a draft award. A draft award basically is that you prepare the draft, you circulate the draft for parties to comment upon, which is quite rarely done, but sometimes there may be an arbitral agreement to that. There's provisional awards where you actually award a particular amount of sum subject to a final decision later, because to keep the cash flow flowing. The institutional awards, you have certain kinds of institutions may actually have arbitrations, and it may be they issue awards. Jurisdictional awards, sometimes you have a jurisdictional challenge, then you have to actually decide that, and that will be a jurisdictional award. Straight away it may be going to the costs for it to be tested and come back. There could be a cost, especially when it's bifurcated. After liability or quantum is done, they may want to have a separate award on cost and or interest. But I think the most important thing you must remember, an award that is final, interim or partial is actually decides on the substance, and it is final and binding, disposes of the matter completely. So that has to be actually differentiated from procedural orders. Procedural orders deal with procedure and they do not deal with the substance, and procedural orders can never be challenged in the sense unless they cross the line of, let's say, due process. That means you do not give them an opportunity, and perhaps that need to be set aside, because the courts will normally will not interfere, because you will set a number of procedural orders for moving the arbitration ahead. Now, what is the requisites of writing an award? I think the important part is that what we call formal requirements. The formal requirements is that basically writing. I already talked about it. It must be in writing. There must be signature. You must identify the parties. There could be a language requirement, because international arbitration is not done only in English. English is only one of the languages. If you go to China, I've done arbitration in China for CIArb. I've sat as a co-arbitrator, and the language was Chinese. The award had to be written in Chinese. The proceedings were in Chinese, but we had simultaneous translation and all these things. The other procedural formal requirement is that you have to write, what do we say, some people call it, in the old days, I said it's called recitals, but now it's called procedural history. And then you must date the award. You must actually seat the award, seat or place of arbitration. That is very important. So, that affects the law that is applicable and how the setting aside and enforcement is going to be done. And then there is such a thing called notification. And then you must comply with the fundamental rules at the seat of the arbitration and the likely place of enforcement. So you have to think about that as you're writing the award. And it must qualify as an award under the New York Convention, which is actually disposing of the matter. And then you are writing the awards for whom? You're writing the awards for the parties, you're writing the awards for the lawyers, you're writing the award sometimes for the arbitral institution, let's say ICC, SIAC, or AIAC or whatever it is, who's administering. But most important, you're writing the award for the court of enforcement. Because when you want to enforce the award, they have to take it for enforcement in the court, unless the parties pay up or settle it, or they actually, sometimes people use the award to do a settlement, or sometimes they actually pay up and take it as binding. So I think sometimes when you actually think about why the award is written for, people want to know the reasons. So we will talk about that a bit later. But you must remember, I'm just giving you one way of doing an award. There are many ways of doing an award, and you must be quite conscious that there is no set form for an award, except for the formal requirements that it must have writing, signature, and all these things. But you must look at the arbitration agreement. Does it require the award to be written in a particular way? Do the arbitration rules require you to do it in another way? What is the law that governs it? So remember that. So it's very important. Now, what is the essential contents of the award? Okay, you must remember this. Just remember that you have to talk about the type of award, who are the parties, what is the contract. There must be a contract. There could be an arbitration clause. Remember the idea of severability. The arbitration clause can be actually separate from the contract. Even the contract is null and void, the arbitration clause still survives, because it has to decide a dispute or difference. You must talk about the appointment of the arbitrator. You have to identify what are the dispute details. You set out the procedure that required to actually carry out the during the arbitration. You will go through a number of steps, from commencement, having a case management meeting. Then you may actually order for pleadings to be exchanged, bundling. You may have discovery. inspection, you may even have witness statements, then you will actually have a hearing and then submissions. So all that procedural history, you have to set it out in number 8. And then when you write the award, you will actually set out the issues. And for each of the issues, you will do the reasoning. And then you will then make a decision on each of the issues based on your reasoning. Then normally you then bring everything to summary. And then the last part is called the award, which is the dispositive part of the award. Substantive parts, this is what you must remember. The award must resolve all the things that are submitted to you as an arbitrator. You must not think about things going beyond what it's been submitted to you. That means you must not go and make a decision on something that you're not asked to make a decision in the arbitration agreement or in the submission to arbitration. You must say things in a final, unconditional, and you must be very certain, and the award must be certain, and it must be capable of performance by the parties. And ultimately, the most important thing, it must actually be also be enforced by the courts. For India particularly, you must be actually not be contrary to the public policy of India. So I think that, because India, I think, has more, I notice cases that are coming out. So I think Mustil and Boyd, if you're younger, you won't remember, because I'm older. This is we will say our Bible at that time, when in the 90s, it is Mustil and Boyd is the book that we use. Perhaps now you're using Gary Bond or you're using Redford and Hunter, but Mustil and Boyd at that time, they said is that a national court will not enforce an award unless it's cogent, it is complete, certain and final, therefore it will be enforceable. So remember that. Moving on, now we will deal with a special thing called reasons. When you deal with reasons in an award, you will be presented evidence. And the evidence will come out from after they may have witnesses, they may have witness statements, they will put documents before you and all these things. And after that is done, they will submit on what is the value of the evidence. So when you deal with evidence, you must remember how you're going to, all the rules of evidence come in, but normally they don't apply to arbitration. We always say that arbitration, the Evidence Act doesn't apply to arbitration. But the most important thing is that the rules seem to be the same, because you, at the end of it, is what is the probative value of that evidence. You must remember that. And then as far as possible, try to ascertain what are the agreed facts. There must be something that can be agreed. They must agree there was a contract. Maybe that is the basic thing that they are disagreeing about. Then you must agree what facts they are actually, there must be some agreed facts or some, or all totally disagreed, but then you will have to set out that there is some common facts. And then you have to identify the issues in dispute. And the issues could be, let's say 10 issues, depends how you, one could be, is there a contract? Or what is the contract? What are the terms of the contract? Was this event a breach? So that those could be an issue. And then after that, you must make findings of fact. And then you must apply it to the law. And finally, you must make a decision. This is the hard part. The arbitrator's toughest job, if you say, it will always is to make a decision. And I tell you sometimes, you will be looking at the issues, you come to the findings of fact, you apply the law, and you may struggle to make that decision, but you have to make a decision at the end. Now I'm giving you all a format of a reasoned award. Basically, first you have a cover page, you set out the legislation, and you actually say it is a matter of arbitration between who's the claimant, the name of the claimant, name of the respondent. You label the nature of the award. At the bottom of the cover page, put the date of the award and put your name, yes, arbitrator. Go on to the next page, you talk about the procedural history. Then in the procedural history, I've already explained to you all, it's actually sometimes a blow-by-blow account how you came to the final completion of the award when you're writing the award. And then you may, most likely, most arbitrations are actually commercial matters. There will be a contract. You have to state the nature, the date, the parties to the contract. Now, it's very important. Your power as an arbitrator comes from the arbitration agreement. And you must actually put out the arbitration agreement and clearly identify where normally, sometimes you may not have an arbitration agreement. Parties may have agreed to your appointment mutually, and they have agreed to a ad hoc submission to arbitration. And you have to actually set out what they have agreed upon so that your jurisdiction is quite clear. You should state next after that is there was actually a dispute or difference that came out from during the performance of the contract or during the currency of the contract, and then you briefly outline its nature. Then you talk about your appointment. Just now we talked about the arbitration agreement. Now we talk about how were you appointed as arbitrator? State by whom? Who asked you to become arbitrator? Did they write to you? Did you get an institutional appointment? And what was that document which gives you that power as arbitrator? And of course, somebody appoints you, you have to accept it. So that it could be accepted by conduct, by calling a preliminary meeting, but I generally will write and say I accept it subject to my terms of appointment. And you may set up, but you need not say your terms of appointment in detail in the award itself. Then next thing is that talk about the interlocutory matters. This is what we call the procedural history that are relevant to the hearing. And you talk about what parties were doing. Did they agree to extend your jurisdiction during the arbitration? Whether you had to make some rulings on jurisdiction, there was a challenge. And perhaps you did some peremptory orders, because somebody didn't turn up or somebody defaulted, didn't submit their pleadings on time, and then went silent. And then you had to say, a peremptory order is an unless order. I think you all would know that you say, unless you do this, I will proceed. And I'll take it as if you have, you'll find in most arbitration acts, especially unsettled model law, there are what is called default proceedings. And then whether what kind of cross-examination you all had, whether it's a witness statement, whether it's a limited hearing system, or whether you all had free flow forever, all that will be discussed in interlocutory matters. Now, if you have an inspection or you made a site visit, you should talk about it, state when it happened, who attended the meeting, who attended the site inspection, and what did you all actually do? Was it a site visit to take evidence, or was it just a site inspection just to look at the place? There's a difference, because a site inspection or visit to take evidence, there must be some kind of evidence recording. That means parties must be given an opportunity to present, to talk and explain, and the other party can explain. So, or, sometimes I go to site meetings, I say, y'all just show me what y'all want me to see. There is no evidence taking. I just see what is at the site, and then I come away. So you have to actually craft your site visit very carefully. And then this is a important statement which I've been using. This is something that I use in all arbitrations, whether it's institutional arbitration or ad hoc arbitration. I will say that part of the award, I will say, and now I, having accepted the appointment as arbitrator, having taken upon myself the burden of this arbitration, having heard the parties' claims, defense, and having viewed or counterclaims, and having viewed and considered carefully all the documents, all the evidence presented, and all the written submissions by them, do hereby make and publish this final award as set out after this. This is where the award comes in. All this before that is all explaining that you have done the thing properly. So when you actually put this in, when the court says, somebody may come and say that, in his actually detailed reasoning, he didn't refer to this document. But the court can see that you have actually referred to all the documents because you make that statement. Okay, next going to possible sections. This is typical sections. What is the dispute? Maybe a topic, you have to give background, what is led to the dispute, what are the agreed in non-judgmental language. You don't use words like unfortunately, predictably, as may be expected. Don't write things that are actually emotive. Because you are a judge, you are an arbitrator, you're not actually a counsel, trying to persuade somebody. You are trying to set out the facts, as you say. So you just state the facts, you state what they say, and then you make a factual finding. So if you notice, I say that on the 15th of July 2019, delivery was done. And then when it was done, the claimant alleged it was a wrong type of equipment. And then the delivery was actually done on this date. That's all. You don't have to go through the other emotive thing, because it will give you a sense that maybe you're biased, so you want to avoid that. So I've actually then for issues, you may be, when is the contract made? Was when there are exchange of letters, how was the letters actually done? If the contract, was it varied? And if it's varied, in what way it is varied? So these are the things you actually will do when you are in practice, is it? When you, or you're answering your exam question, if it's a practice question, this is the way you'll be answering it. So this useful skill is at the end of it, what you are being taught. And if you are, let's say, an arbitrator, of course, you will know this is the way that you have to write it out, because this is what people are interested in, the reasoning, the way you're saying things. And then at the end of it, what is the final issue? Is there a breach of contract? From which date does the interest run? Should damages be awarded? What is the appropriate rate of interest that you have to think about? Should it be compound or simple? Or if it's compound, what arrest it should be? So you have to come out for each item with a reasoned conclusion, for each issue. So for each issue, what I would suggest that normally you set out what is in the pleadings in brief form. You set out this, sometimes it will be this is what they are claiming and all these things. This is the issue. Then you talk about the evidence that was presented. After the evidence that is presented, then you talk about the submissions that were made by the parties. So you can see that you're actually going through a very organized, structured process, and then you will give an example for each of the issue, a title, date of contract. You're going to deal with that. Next one, the letter of 16th of July. Then you may talk about variation was there, and then added terms. See, I'm just trying to help you all to break down the thing. And then again, when you actually summarize the evidence, just now I talked about, you have to summarize the evidence. You can use this kind of words, related, recalled, told, gave evidence, testified, corroborated. And if it's cross-examined, let's say if it's been cross-examined, you say admitted, considered, accepted, maintained, countered, replied, all these useful words. And when you summarize, when you go to their submissions, and you're looking at the party submissions, you can say agreed, submitted, considered, contended, replied, suggested, and all these things. So you can see the words that you have to use. So then after that, you have to have findings, because you remember you have evidence, then you have come to submissions, then you're now, then you have to make a finding. And you have to state what is the factual evidence you accept. And if there's an expert evidence involved, and remember, expert evidence is different from factual evidence, because expert evidence is opinion evidence. It is evidence that is actually somebody's opinion, which is for the tribunal to decide. So do you see whether you accept the expert evidence? But factual evidence is about stating the state of affairs. Then if you have accepted the factual evidence, then you have rejected by implication the other side. But I would suggest that you actually say you have rejected that evidence. Don't say I've accepted this evidence and then keep quiet, because sometimes it is not clear whether you have whether you have rejected the other side. So then when there's a legal submission made, make a ruling on it. For example, the date of the contract. What is the interpretation that you make? So make a ruling on it. Then following for example, I'm giving you an example, a very simple example, that you actually say you set out each issue, and then the finding on the issue, you equate this, the facts of this date was a counter offer by the respondent's offer on 15th of May. And then this counter offer was accepted by this letter. And then the contract was made on this date. You can see there is actually a logic that someone can follow. That's what is very important. And then when you look at damages, after you come to this, at the end of it, a lot of it is about money. Sometimes there's a declaration required. You may look at the remedies they ask for and the reliefs they seek. And it will be similar. A lot of things are similar. There will be a declaration about a breach. There could be actually, then at the end of it, damages. They ask for work done or whatever it is. So you actually, when you're looking at the damages, you look at the duties of the parties. You look at the breaches that have suffered. And then whether there's some kind of loss. Look at the loss. And then will damages actually compensate that loss? Then you calculate the figures that come out from it. At the end of it, it comes down to dollars and cents. You may be guided with submissions of the parties, but you will have to actually put them together and make an assessment. And then once you assess it, what is the figure? When does it run from? What date does it start? From the cause of action? Normally it is from the cause of action, but certain damages may actually come out at different times. Let's say there are a number of interim certificates. So it may run from, payments are made in a staggered form, there's stage payments. So I think there are different issues. I'm just talking generally, because you can ask me questions later. So calculation. I've given an example of calculation. Okay, you can share the slides. I've got no problems at all. You must then calculate how, because there will be a figure, but most probably you're helped with the submissions. In the submissions, people will do the calculations for you, and you may actually transpose those calculations, check them, and see whether you accept that, if the evidence supports that, and your legal submission. Now, there's one important thing that always comes up after that, because when there is money loss, then you will have to actually decide on the interest. Interest is payable because money basically is not being paid, and there's a cost to money, and that cost is normally called interest. And there are two types of interest that you have to deal with in an award. There's one called pre-award interest, because the process of arbitration takes time. Okay, in India, it'll be 12 months, compulsory plus another 6 months. So if that is already time, But before they bring the thing to arbitration, the course of action could have started, let's say, 2 years earlier. So between the course of action and the date of your award, that means you've gone through the arbitral process and published your award, you're going to publish your award, there will be what is called pre-award interest. So you have to deal with that. Now, after the pre-award interest, there's another period. When you issue the award and some payment is due, and the person takes time to pay, that will also attract interest until the actual realization of the interest. So you have to actually state whether it's simple interest, what is the rate of interest, and then from the period it runs, pre-award and post-award. So what will happen is, at the end of it, you cover the cost of money that is owed. Award on cost is also very important, because an award on cost arbitration is not cheap. I think just realize it costs money, just like litigation and most other processes. There's a cost involved in bringing the matter. But in arbitration, you can really recover the actual cost compared to courts. The courts, somehow or other, I notice, they will never give you full cost on an indemnity basis. But in arbitration, you don't get it on an indemnity basis. You may get it on a party-to-party reasonable cost basis, but you may have to show evidence of the money paid. So there are two rules in the world about cost. But let's say we are from the common law countries. But if this is in the common law countries, there are two rules. One is called the American rule, and one is called the common law rule, British rule. the American rule is that no matter who wins or loses, you carry your own cost. But in most of our jurisdictions, it will be what we call the British rule, which is basically cost follows event. The loser pays. And then you will actually look at exceptions if you don't want to follow that rule. And I think if you have done law, that is the same rules applied to arbitration. So you have to look whether there's one thing that is quite interesting that is going on. People are encouraged, in arbitration to settle matters. If they can settle matters, it's a public policy that settling of arbitration disputes or disputes before it goes to arbitration is a good thing. It is encouraged. And there's such a thing called what is that? Open or sealed offer. Have you all heard of Contd bank offer? So if you have a Contd bank offer, that has an effect on the cost. A Contd bank offer, for example, at the beginning, let's say the claimant or the respondent could be either party, and because even the respondent may have a counterclaim. And when you have a counterclaim or your claim, you know that the arbitrator is going to issue or make an award of certain amount. So this is like you want to arrest the cost because it costs so much to go to an arbitration. So at the point you start, you may try to make an offer to settle. And you offer an amount, and it could be stated without prejudice, except for cost, save for cost. So that is the way a normal seal offer or Contd bank offer is done. And what will happen, the impact of that is that when the arbitrator makes that decision on the final sum, if that sum that you offered was actually higher than the final sum, all the costs, even if you win the case, is carried by the person who didn't take up the offer. That is one of the considerations. And I tell you, you will find that many people do this, particularly when the cost is very high and they know they have a losing case, they have to pay something, and they deal with it. They deal with it in this way. Then the conduct of the winning party, whether they put in so many claims that it was of no consequence after that, that they won very little. Then, as I said, exaggerated claims. Then did the winning party delay? Sometimes winning parties, they actually have, they will change 5 counsels in the process and delay the thing, because sometimes, you see in arbitration, sometimes it's not a commercial matter anymore. Sometimes it's about personalities, strong feelings. You want to cause hurt. I've seen all these things in my career where people come there for a collateral purpose, not only to settle the thing, but also to inflict pain. And they will try to delay, they will do all kinds of things. So sometimes, you will have to tell them, look, if you continue like this, there could be actually taken into consideration an adverse cause of finding against you, even if you win. So I think that has to be measured. But normally, if you win and things go smoothly, cost follows event. So I think that for us is quite clear. Then we move on to the award itself. The award itself, I think, very straightforward. You must say what is the total amount if it's a money thing. If there's a declaration, you talk about a declaration. And then on the amount of the money, how much is to be paid? And then who is going to bear the cost? And then you must make this statement, finally. All other requests and claims of the parties are rejected. That means you have left nothing in the submission to arbitration for you to be reopened. One of the things that you actually not dealt with, they may come ask for your additional award. But if you put something like this and you have dealt with all of it, then basically they cannot actually ask you for an additional award. That is another type of award that you will have interpretation, or if you have not given the reasons properly, they can ask for you to interpret the award. So that means they're asking you to give me more reasons, explain to me, that properly, So the dispositive part of the award is, I've given this, I give you all an example, pay so much. Pay simple interest, what percentage? Pay costs. This is the arbitrator's fees. Then pay the party's costs, all other requests. And then you will notice at the bottom, award made and published by me or made by me on the 23rd of May. The seat of arbitration is in New Delhi. This is very important. You must actually put this in. Where is the seat of the arbitration? Because that will be the governing law, lex arbitri, that they will try to set aside at this seat. And then you must sign it. You must sign it. There is actually no need to witness. I mean, the old days when I first started my career as an arbitrator, I will get my secretary to witness. I have some old awards. You know, I was quite in the 90s. And it was witnessed by my secretary. And I think now, you know, that the reason being is that, let's say, if you're getting a very old person, or very there's some problem of authenticity of the signature, that person can come and actually testify that you did it. Now, okay, let's go to the checklist. Now, going back to everything again, going back to summary again. Now, what does your award have a heading? What legislation? Where are you working on? What is the Arbitration Act that's applicable? Is there a set of institutional rules applicable? Or have you all in the ad hoc arbitration decided that you wanted to use the uncitral arbitration rules? Then designation of the parties. I talk about recitals, it could be procedural history. You know, procedural history. Then I talk about the clause covering the hearing of the parties, which is about the arbitration agreement, agreed facts, issues in contention, holding of facts, holding of law, and reasons for each issue. Is there a decision on each issue? You have to check. Is there a decision on interest? Have you brought everything to summary and put it in the into the award clause? And then, is there a clear calculation of damages? Now, who is supposed to pay who? And is there a time that you want to set for it? Is there a decision on the party's cost? Is there on the cost of the award, which is the arbitrator's fees? And then name, signature, seat, date, and the arbitrator is signing. So I think once you get that, then you are ready. The award is done. The award is done. You are ready to do what we call publication and notification. What it means, you have completed the award. Now you have to tell the parties. If it's an institution, the institution will tell the parties. Now, it is very important to actually, publication is quite important because it may be in regard to limitation. Because once the arbitration starts, limitation stops. And let's say you suspended the arbitration, or the arbitration is terminated, then limitation starts to run again. I mean, basically is that is the okay. Once the award is signed by the arbitrator ends. Arbitration ends. The arbitrator becomes functus officio, and then it is mandatory that a signed copy to be delivered to each party. But delivery doesn't mean you go and send it to them. It is telling them that the award is ready. Please, you can collect it, but you pay my fees. If it's from an institution, pay the institution the fees. But normally institutions, they will collect the money upfront. ICC, SIAC, or even AIAC, before you start the arbitration, they will collect all the fees. They will calculate based on the first an estimate, after that on the actual amount, and they will ensure that the money is there before they allow you to start the arbitration. So you have to look at the rules, how it goes. So the arbitrator is a lien on the award, and then they will retain it until the payment of the fees. And then I think the date of the receipt of the copy of the award is very important for the setting aside application, and also for the enforcement and recognition and enforcement. So I think that is basically what I have to say about the award. I don't know whether I did 45 minutes or more. So you need some certain level of skill to write a well-reasoned award, and it must meet both formal and substantive requirements. It must be cogent, it must be complete, it must be certain, it must be final, then it will be enforceable. So you must actually give consideration to ensure that the award rendered is not caught on grounds that will set it aside for want of reason, or is it contrary public policy. You will have to look at all those things, and then you have dealt with all the issues. I think that's the point I've made. Then let me just shut this one down and go back to the main. How do I start? Stop share. Is it okay? You controlled it. Okay, thank you.
Thank you so much, sir. It was really enlightening, and I learned a lot of this, and especially being a beginner and just starting out as a tribunal secretary, this has given me enough inspiration to become an arbitrator in the near future. And of course, our participants who have been have varied experiences. We have arbitrators, sitting arbitrators from lots of countries, and we have law students and practitioners and even technical people as well. So I guess they have quite a lot of questions, and if you have any other questions, you can please put it in the Q&A box as well. But before we move on to that, I would just like to have one question from my side. So we talked about how to write an award for the last 45 minutes, but that is how a sole arbitrator is writing an award. So I would like your view on how an arbitral tribunal will go about writing an award. That is, if there is more than a single arbitrator, or if there is a dissenting award. So what will that entail?
Okay. Normally when tribunal is constituted, we will actually let's say a panel of 3. There will be a chair. There will be a presiding arbitrator. So the first way we will deal with it is we will do starting the arbitration. We will normally empower the chair will actually control the arbitration, but will consult the co-arbitrators. So there will be procedural rulings will be normally issued by or procedural orders will be issued by the chair, but normally in consultation with the co-arbitrators. Sometimes co-arbitrators and sometimes even the legislation or sometimes the rules may allow the presiding arbitrator to give the procedural directions, and it will be valid. But when it comes to writing of the award, all 3 must participate. I think that is the key to the whole thing. And each person has 1 vote. And just like Parliament, majority rules. So the award becomes valid as long as there is a majority decision. But the way we normally do is to arrive at a consensus. So I think, one of the reasons why you have a 3-panel tribunal is each party may appoint their own arbitrators, and they will have a chair. There will be a balance. So normally you find when it's done in a award, 3-panel award, you will find that there will be it will not be very extreme. It will never take extreme. Okay, then you will have situations, and we do have situations where there are disagreements. There will be discussions. We will try to persuade. Each of us will try to persuade. Okay, writing the award again, talking about how you're going to write the award. Sometimes the draft is prepared by most likely the chair has to prepare the draft based on the submissions. But before preparing the draft, there will be an initial discussion on what direction should it go. Because we have heard the evidence, we perhaps have some oral submissions, and we may have a feel of how the thing should go. And later, when we have the written submissions coming in, then we will have a further discussion, and then a draft will be done. Now, the draft can be done in many ways. Sometimes it could be it has normally to be the chair, but sometimes it's done by, let's say, all 3 arbitrators splitting up the work and saying that we do it like that. But sometimes it's not very satisfactory because somebody has to edit it to make it complete. Then let's say you have a situation where one arbitrator disagrees, dissents. I think that's what you asked for. What actually happens? Normally life goes on, the decision has to be rendered. And if you cannot persuade the person to actually come around to the majority decision, then the majority will issue the award with a statement, because normally the dissenting arbitrator will not sign the award. In international arbitration, there should not be, except for ITSIC arbitrations and certain kinds of arbitration, normally there's no dissenting award. There could be an exchange of emails or about the issues that are disagreed. But when you actually sign the award, you must put down a statement that the dissenting arbitrator was given an opportunity, and he or she did not agree to the majority decision. And then that becomes the binding award. But problem is that I think sometimes many, especially in India, many dissenting arbitrators do write dissenting awards. What is the value of a dissenting award? Actually, it is to be disregarded unless there is actually serious breaches of rules of natural justice or proprietary and all these things. It just becomes an opinion. It is not binding. So that's the way it works. So sorry, it's a long explanation. I hope it's sufficient. Yeah.
Thank you so much, sir. Cleared lots of things up, and I hope we can move on to the Q&A session of the evening. We have quite a lot of questions, and I'll try to ask you the maximum number of questions as much as I can. So, the first question is by Mr. Dineshwar Gav. Are there any recommended formats, guidelines of award writing published by any regulatory body or reputed institutions?
There is. I think ICC, and then most of the institutions, especially ICC, has actually a format. If you go into any textbook, you will have, in my own textbook, I took a format from Bernstein. It varies. It varies. When I first started in the arena, I had a mentor. Who, like a tribunal secretary, you get mentored, and then you see examples of how awards are done. And early in my career, I used to collect awards wherever I could get. It's supposed to be confidential and private, but somehow the whole world seems to have it. But of course, certain kinds of awards are actually made public. And then there is actually a move by a lot of arbitral institutions like Stockholm, even ICC, doing redacted awards. You have seen that. So you can look at those samples. You will find the format may be running. Sometimes you find a technical person may write an award slightly different from a legally trained person or a lawyer. So the formats may vary, but the contents of an enforceable award will be the same. You can't run from that.
Sure. And of course, the format which you shared with us today can also be used for the reference.
Yes, and that is something that I developed, but it's more of the Chartered Institute way of writing awards. If you go, Chartered Institute has come out with 2 protocols on drafting of awards. And this is some of the things. But if you go and look at, there are many, you look at IBA, they have what is called a toolkit for writing awards. So, you can download it from the internet. It is a very simple thing. At the end of it, the important part of an award, the formalities must be met. That the formal things make sure that it can be enforced. The substantive things make sure that it cannot be challenged.
Definitely.
You see, so I think you look at the 2 ways it's cutting. So when you put both together, then it becomes something that cannot be challenged and can be enforced.
Sure. So I have one more question from Mr. Satish. Is it necessary to interpret and comment on the evidence through cross-examination of all the witnesses?
Actually, it's only what is relevant. You need not. Let's say somebody brings, I've said in arbitrations where there are 10 witnesses. Of course, when you write the award, you identify the 10 witnesses. And I'm very polite normally. I say all of their evidence was very useful. You know, at the bottom line, say the claimant had, let's say, 10 witnesses, the respondent had, let's say, 12 witnesses, and then I would say that, you know, I appreciate they coming to give us evidence, and I found it very useful. So, but then when you actually deal with the issues, you only deal with the relevant evidence. So certain witnesses may not be mentioned at all. Or even if you mention them, you will say that, you know, that part of the evidence was not applicable when they gave, or you want to deal with it, you actually have to evaluate the probative value of the evidence. Because once they come in and you know, orality is one of the modern things that's happening in arbitration. You will see orality is becoming less and less. You know, people do not actually depend so much on cross-examination. Of course, you have you know, moods and all these things, but in reality, I give you an example how an arbitration works. Let's say if I'm doing it, I will nowadays, let's say, get appointed. I may see you for the first time at a preliminary meeting, but nowadays we have case management by Zoom or telephone conference, and then a procedural order will be issued, and a procedural order will set out in that pleadings, the documents, discovery, and all these items, including hearing dates. And then the next time when they deliver all these things, the next time I see them is for that hearing. And let's say the hearing is fixed for 5 days or 4 days. Parties will actually present their witnesses, because we already have, let's say, the other thing is that there is actually, as I said, orality is being reduced. So you may have witness statements, and there is actually even now rebuttal witness statements. So the cross-examination becomes limited to not the entire witness statement, but to the little difference that arises from these two witness statements. So I think that is the modern way of doing things. I think most institutions are quite particular. You know, it's very difficult to finish it. Let's say, especially in India, if you actually do not get the hearing finished in one sitting, you may not meet the 12-month requirement, which is, I think, you know, you have to actually force yourself. So that means you have to cut back on the orality. But I think the most important thing is the equality principle. You must treat both parties give them equal opportunity or reasonable opportunity to present their case. It depends on what the legislation says. If the legislation in certain countries say full opportunity, then it's a bit difficult. So you have to actually craft your ways of managing the arbitration hearing. You know, the techniques people do is they will deal, let's say, with expert witnesses. They will put all the expert witnesses together. They call it something called hot tubbing. You hear about that, you know. So that means basically everybody, the expert witnesses are put together. Questions will be directed to them. It's all recorded. There'll be a transcript kept and all these things, and then the things are clarified, and that will be the evidence that's presented to the tribunal. Witnesses themselves, there could be limited time hearing, where you know, I have done limited time hearings where parties are quite conscious of cost and they want to finish this quickly. They agree, let's say, each party will be given 2 days to present their evidence. So they can do anything with that 2 days. I mean, 2 days means, let's say, 7 hours each day. That will be 14 hours. You can come and do a song and dance, or you want to actually bring some witnesses, or you want to, so we will keep time. And if the party asks a question, interrupt, the time goes to the other side. And then if this party actually presents the thing, that time goes to the person. So actually we have a monitoring. So it's a chess clock. It is limited time. It works very well. In fact, I found whenever I did a limited time, people finish their hearing before the time allocated, which is very strange, because what actually happens in a limited time hearing is that once the time is up, you stop. So you cannot go on easy stroll. That means you're going straight to the point. You have to get as much information out and put it to the tribunal to listen to this.
Thank you, sir. So I think we're running short on time, so I'll just quickly run through two, maybe couple of questions. An anonymous attendee is posted. What happens when parties settle midway? So I guess they settle during the course of proceedings.
Depends. I think normally the lawyers cry. They get quite upset. No, I'm not. Maybe sometimes it has to be settled. We encourage settlement. In fact, I think, you can see how things are happening nowadays. They have mediation, what they call up. Yes. Why they do that is they try to get the parties to settle midway. The actual answer when parties settle midway, there are two options. First option is to terminate the arbitration. That means the parties have settled, they have gone into a settlement agreement, and they will request jointly to the arbitrator or the arbitral tribunal to terminate the arbitration. And there is what is called a termination order. So you will draft the termination order, you will circulate the termination order with the truth to the parties, and then after which you will issue it. The second one, they may ask you to record their settlement in an consent award or an agreed award. So a particular legislation there is saying, and normally the award, the consent award, the way it is written, the recitals will be the same. That means the procedural history, all the things I talked about, and then, but only thing is that you will come, when you come to the operative part, you will just say that the parties between both that have informed me on this date, this is the agreement between them, and you will check that it is enforceable. And then they will state what has to be done by what. Sometimes there may be deferred payments and all these things. All that has to be recorded as an award. And then you will date it, and you will sign it, and you will issue it to them. I think so. That is how it is done. A consent award. So parties settling halfway, it is quite normal. Because sometimes they get frightened of the arbitrator, because they say that this arbitrator is terrible because so useless. We better sort out our problems ourselves. Or they may say the arbitrator is good. The answer is very clear because the evidence is coming out so clearly that I'm going to lose. I might as well sort this out now. I cut back on the cost. Or the third thing is that parties genuinely, you see, always assume in any situation that the parties are always talking to each other, trying to settle the situation. Certain groups of people have more probability of settling things. They don't go to the bitter end. Business people who are very, very practical about the way they do things, they tend to settle. And you see, the next movement that I see in arbitration is not arbitration. It's going to be the other way, dispute prevention. It's going to be dispute avoidance. All that, rather than going to the dispute itself, when they go to the dispute, it's going to become smaller. In fact, I think that is the future. That's why you see the Singapore Mediation Convention, international recognition of settlement awards, settlement agreements. So if you can do all those kind of things, and then you see a lot of dissatisfaction with arbitration because of cost, time, and then it's too legalistic, all the same issues. So they say, okay, we forget about rights-based. We don't talk about rights anymore. Let's talk about interest-based. Let's try to do mediation. Perhaps a neutral who's very, very clever and skillful can convince us to actually do some kind of settlement, which may be novel in some ways, which may be novel. Let's say it may not deal with the contract itself. There may be some payment because sometimes somebody is impecunious enough for that moment, a cash flow problem. I cannot pay, but I need time. So they may come up with a solution. Okay, the next project you give it to me and you will pay on that project. This one I take a loss, something like that. So I'm seeing things like that. I think the future of dispute resolution, that's why we have done now the great emphasis on ADR, alternate dispute resolution. It is going to move away from arbitration per se. Arbitration will always stay there because someone cannot actually, many people cannot actually agree. They cannot actually come to some consensus. And they have to get a third party, a neutral party, to make a decision based on the facts and the law. They want what is, say, a binding decision. And normally they want that, so that there are many reasons why people want it. Sometimes if you're a government department, you don't want to take the blame. If you're a government department, because somebody else has made the mistake, and you will say, why should I, actually settle this? They will say, I'm corrupt. I better go through arbitration, get that award from a third party, and then I just execute the award. Nobody will say anything about me. Sometimes there are other reasons, time, many reasons, So I think we have to look at it holistically. We can have another discussion about this, in fact, the trends of how I see things are going.
Definitely. So thank you so much for answering this. And I guess we've crossed our time limit as well. So I'll just like to mention this question alone before I end my session. Captain Dharman Murali and Priya Iyengar and quite few others actually asked for your books and your materials if available online, which they can purchase, and any other material which is available online for them to study. So I guess
no, these slides are there, but actually, my books I think are available. In fact, last year I wrote this book. This book. I wrote this last year. I think this book has been around, I think, from 2016. So basically, most of the things that I've talked about are in this book. This one is actually a law practice. I'm writing a book for India, by the way. There's a team helping me. Of course, there may be other people may be interested. I'm giving a young group of people working with me, associates and clever lawyers, very clever lawyers, and also students doing the research. And then we are going to actually come out with a book by this year end, hopefully, which will be modeled on this law practice and procedure for India. So because I'm very dependent on them, because they are actually quite skillful, and I think then you may have a book that is actually pertinent to India, with Indian case law, Indian procedure, because Indian procedure is slightly different. In fact, I've done recently, I think last year I did an ICC arbitration where I chaired in India. And of course, ICC arbitrations around the world are similar because the rules are similar. But you can see the procedure is slightly different. And then when you do the award, the considerations are different. Some of the considerations, but the main points that I've talked about are the same.
Definitely.
So, but the books, you can get it from anywhere that you, the publisher, one is published by LexisNexis. The other one is published by Sweet and Maxwell. Of course, I have a number of books. I'm working on 3 books now, one on adjudication, one on construction law, and then of course this Indian book, So I've been writing articles, and been enjoying myself on these things.
Really happy to hear that. And we'll definitely share all the links to the participants via email as well. And
yes.
I apologize for not making sure we answer the other questions. So if you have any unanswered questions which you'd like to ask the speaker or the institution, you can please email those questions to kfcri.adr@gmail.com. So we'll try to get the questions answered as much as possible. With this, I guess we've come to the end of the session. I thank Professor Sundra Rajoo for joining us. Thank you, sir.
Thank you. Thank you.
So apologies, sir. Sir, can you please unmute yourself, please?
I have to unmute myself. Oh,
Inbavijayan.
Yeah, yes.
Yeah, thank you, sir.
Thank you all, and it was really a wonderful session, having the closure of the arbitration, that is the award. I have to be personally thanking Professor Sundra, because I am into arbitration only because of him. The motivation, what he gave some 15 years back, when I just happened to meet him in Malaysia as well as virtually, he guided me a lot. The same guidance I could see, the energy I could see, the participants would be really benefited out of the message what he has conveyed about an award, particularly the latest development is the award. I am very clear that Professor would come with a new idea, that is a new book on award writing. The only one exclusively available is what the days when we started was the Ray Turner's book on arbitral award. I think Professor Sundra would come out with another treatise on award writing, so that it will be beneficial for all practitioners, law students, as well as the techno-legal professionals who are into the arbitration field. And finally, KFCRI is very thankful for Professor, because Professor is a guiding mentor for all practitioners, whether young or old, or even practitioners coming from different arena. He himself is a town planner. That itself we can show that to what extent other professionals, not only the legal profession, other professionals can get the momentum of arbitration and facilitate arbitration, not only in domestic but also in international. And with this few words, I like my colleague Dave to share the other prospects and how we are going to proceed. Thank you.
Thank you, sir. Thank you, Professor, for such a valuable interaction. Now, a bit of logistics. We'll update regarding the other webinars very soon via mail. And many participants, many attendees have asked to share with the slides. That will reach via mail. We'll share the slides. And we are planned for an online AAP on June 7. I'll just like to refer some guidance to how to register for the online AAP, which is going to be conducted on June 7. So you have to go to the KFCRI page, which is kfcri.org. In that page, you have the upper tab option called accreditation. If you click that, there is the option of arbitration, conciliation, mediation, negotiation, and other media practices. As of now, since we are conducting an online AAP course on June 7 for arbitration, please click on the arbitration tab and you have an option called associate. Any members, any interested candidate can go to this tab and click on this to register yourself. And it's not only for the fresh candidates. Even if you are a practitioner, even you have a good amount of experience in arbitration, do register yourself. On based on this scrutiny committee, we will definitely reach you for giving you an exemption. So the details about the registration is, once you click the registration now, you have to give all your phone number, email address, the other details is asked for, and please do not fail to upload your resume as well your photo, which is given as a file option here, and give it a submit option, and we will your work is done till there, and we will take up the work there, and we'll reach you via mail for the next according to that. So in case if you have any other queries relating to the online AAP, which we are going to conduct on June 7, please reach us via kfcri.adr@gmail.com. And I just want to finish this webinar session by wishing our project advisor, Mr. V.Inbavijayan, who is celebrating his birthday today.
Oh, happy birthday,
sir.
Thank you, Professor. It's my 45th birthday.
No, you're very young, very young, very young. In fact, mine is reversed. I'm 64. So you're 46. Oh, right. But, I was just one point, I just wanted to tell you is that my mentor is actually Ray Turner.
Oh.
I studied under him. I have two mentors in my life. One is the architect mentor who sent me there. Started me on arbitration. And the person who really taught me arbitration was Ray Turner in Leeds. So it was in 1995. That was in mid-career. So I think, it's very, very interesting that you talk about, because at that time he wrote the book, because that was his lecture notes to us.
Oh, sure. Then he had to make the live edition.
I'm very fortunate. We are still in touch. He's alive. He's 90 something. So it's a great honor to hear his name mentioned. There's another person who's also there. It's Michael Needham. They are two great, and both of them are not lawyers, by the way. They are quantity surveyors.
Yeah, Michael Schneider is a value partner. Schneider?
No. We are not talking about Schneider. We are talking about Michael Needham. Needham passed away. He passed away. But he was a quantity surveyor. In the early days in arbitration, it was always by technical people. The lawyers came a bit later. But lawyers used to submit. Construction arbitration. Yeah.
Thank you, Sundra. Thanks a lot.
Okay.
It was really a good session. Thank you.
Thank you.
Thank you all the panelists and thank you all the attendees for such an interaction. I also would like to extend my hearty thanks to my KFCRI team who is working behind the wheel for such a smooth running of this webinar session. Thank you all. I do have mentioned our website detail and the email address for any updates. Please do have a check on that. Thank you. Thank you all.
Okay. Goodbye.
Goodbye. Thank you.